U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I have a good one for you today, and we're going to be talking about a law that it is like amnesty, and it allows you to to obtain your status here through the section 2, so INA section 245I. So it allows you to get your green card without the need to leave. You may have entered the country without permission. You may have also come here and then you overstayed your visa. And because of that, you may be barred from adjustment of status. And so this could be a solution for you. And I want to educate you about this option. Now, keep in mind that to determine whether this could qualify you to get your status here in the United States, you should always get a consultation where we can evaluate in detail and then move forward with an option. Another thing I wanted to say is, we have been talking about the Florida law, the anti immigrant Florida law. And, we've been talking about possible immigration reform that has not happened yet. And due to the current politics, it's probably not going to happen until after the election. I think it really would take a miracle, which I wouldn't mind a miracle happening. But at the same time, I do want to manage your expectations and give you a realistic idea of what is coming. And so I think this is important to evaluate options that are available right now, right? Immigration reform it's coming. I want to keep up the hope that is coming, but it may take a while for us to get there. We have the anti-immigrant law right now, and a lot of people want to know what they can do now. So this is what I'm going to do. I'm going to talk about the tools that we have now. And as a matter of fact, I'm going to spend the next week that we have focusing on the tools that we have now for you to fix your status, to get your green card, even if that means you get to stay here without the need to leave. Now, INA Section 245I does exactly that. Now, the law was passed on December 21st in the year 2000, and it is considered as a form of amnesty because it says that anyone who has had a petition filed for them as like say a family petition or an employment-based petition, or you've had a labor certification done for you. Oh, thank you so much. A labor certification done for you on or before January 14th, 1998. It means that you could possibly qualify to stay here despite the fact that you may have entered without permission or you may have overstayed your visa. You can still go through adjustment of status. You may be required to pay a fine and move on with your life through adjustment of status. Now, they did make a change. So they updated the law and said that now anybody who had a petition filed for them on or before January 14th, 1998 can then change their status here through adjustment of status. And you don't necessarily, you could have been outside of the US when the petition was filed and now you're here. You could have been here already. You could have entered the country without permission and you would still qualify for adjustment of status as long as you met all the requirements. Now, they did update the law to say that if they extended the date to say that if you had a petition filed for you on or before April 30th, 2001, you can also apply for this. All right. So in 2001, that's what occurred. And the only additional requirement is that you would have to show that between January 14th, 1998 and April 30th, 2001, you were if the petition, if the labor certification, if the family petition or the labor certification was filed between that January 14th, 1998 date and the April 30th, 2001 date, you would have to show your physical presence in the United States on December 21st, 2000. So only for those who had the petitions filed within that 2 year period, then 2 years or 3 year period, or almost 3 year period, you would have to show that physical presence in the United States. So that's the difference between those who had their petitions or labor certifications filed before that January 1998 date, and the difference between the individuals who had petitions filed between 1998 and 2001 is the ones between 1998 and 2001, you have to show physical presence, that you're physically present in the United States on December 21st, 2000. Now, the petition doesn't have to be a petition that was successful. So it could have been an approved petition, or it could have been that maybe for some reason you never completed the petition, or maybe the sponsor passed away, maybe they withdrew the petition. But what they do look at is that at the time that the petition was filed, was it approvable? So at the time the petition or the labor certification was filed, was it approvable? It has to be approvable. So it couldn't have been a type of frivolous application, or it couldn't have been, say, an aunt filing for their niece. It can't just be where you can show that a petition was filed, but you have to also show that it was approvable. So, for example, if you had a petition filed for you on by your parent, say your mom filed your petition for you, or I'm going to get into this exciting part of the law, is say the petition was filed for your parent, right? So say your grandparent filed the petition for your parent, and say your grandparent passed away before the petition could be adjudicated, or they passed away when it was approved, but now it was time to go to the embassy. And because of that, say your parent never finished the process. You may have been listed on the petition even as a derivative, meaning you were a dependent that was going to go along with your parent, or that you could have been listed as a derivative on the application. In a case like that, guess what can happen? Say your parent is now here in the US and they want to do adjustment of status. They can do it through this because this was filed before January 14th, 1998, right? And now your parent is here in the US. They can turn around and say they can adjust status based on INA Section 245I, because their parent, which would be your grandparent, filed a petition that was approvable because this is a bona fide parent-child relationship between your parent and your grandparent, so it was approvable. However, just didn't finish because your grandparent passed away. So now your parent is here in the US, and they don't have to show the physical presence because it was filed before that petition was filed before January 14th, 1998. In that case, they could adjust status through Section 245I, even if it doesn't have to be a petition that's related to the previous petition. It can be, now say your parent then now had another relative, say they had their sibling file for them, and now it's time for that application to be processed. The priority date is current and everything, and so all they need to do is do the adjustment of status process. Then they can use Section 245I to complete that application here in the US without the need to leave. But here's the other exciting development. is that, say you came with your parents, say you are here you're listed as a derivative of the application when your grandparent filed for your parent, and you were listed as a derivative, or you could have been a derivative on the application. You were born at that during that time. You were listed as a derivative. You could also apply for adjustment of status based on Section 245I. So it's a valuable form of relief that can not only extend to the person that was petitioned for, that the petition was filed on behalf, but the people who were listed, who are named or could have been named on the application as well. So that's the idea of Section 245I. And this is why it's important to kind of dig a little deeper into your family history to find out, were there previous petitions filed on behalf of your parents, and what happened. Not only petitions, but did any employer ever file any petitions on behalf of your parents? If so, then there may be a labor certification, there may be a petition that's out there that could qualify you to adjust status through Section 245I. So, that in a nutshell is a type of amnesty that was created back in 1998, and then it was not 1998, into December 21st, 2000, and which was extended, allowed you to extend the time that the petition was filed to April 30th, 2001. Um, so, do some digging, do some thinking about that. And if you've had a parent who was sponsored, a petition was filed on their behalf way back then, before April 30th, 2001, you have a shot at staying, and you were a derivative, or you could have been listed as a derivative on the application, then it means that you could qualify for adjustment of status without the need to leave. So do some digging, think deep about what your family history is, and to determine whether you have had any previous filings. And we will be more than happy to evaluate whether you could qualify for this. It's still available. And if this is in your history, then you could stay here. Now, once you apply for this adjustment of status, and this applies whether you cross the border without permission, or whether you came here and you overstayed. And now, once you're going through the process, you do have to pay a fine of about $1,000. And then you get to move forward with your life here and get your papers and not have to worry about leaving. So go ahead, put some questions. If you have additional questions about this, put those questions in the comments. It is one of those provisions that it's because it's so long ago, a lot of people, sometimes you assume that it doesn't apply to you because maybe you weren't named on the application, but it could have been your parents that could be included. And it could even go to your parents in some cases, where you could be included, just depending on your age, because spouses and children may also be able to adjust status, even if at the time they were not born at the time. But if a parent qualifies based on adjustment of status under this provision, then it means that you could go along with your parents. Even if you're born afterwards, you could go along with your parent and get your green card. If you're, of course, if you're considered a child, which is usually under 21 and unmarried. If you're the spouse of someone who can qualify under 245I, it means that you could do the same thing. You could qualify along with your spouse, even if you were not married during that time period. You're married way after. If you can go along with your spouse in the process, if your spouse qualifies to adjust status through 245I. So, do some digging on your part, and just do your due diligence to make sure that you don't already qualify for this type of benefit, because it is there, it is available, and it is there whether you cross the border without permission or you came and overstayed. It's even there if you have other things in your background, if you have additional immigration violations or even a criminal background. Those can still, you can get waivers along with qualifying for Section 245I. You could get a waiver of inadmissibility if you're worried about other issues. So this is what you can do. Schedule an appointment so we can get to talk about what your particular situation is, and then we get straight to work to fix your situation or provide you those options that are available. And this is what the consultation is about. It's about really digging deep into your background to figure out if one of these kinds of reliefs applies to you. And it's a much forgotten. It is a type of relief that is it's overlooked. If sometimes if you go into a consultation and the attorney asks if you're married and you say no, they usually stop there and say you don't have any options, but they don't ask those additional questions that could open up the doors to other options like this one. So that's the difference between my consultations and other attorney consultations. All right. So go ahead, put your questions in the comments. I'm already seeing questions coming in, so I'm going to quickly go through and answer your questions. Now, before I jump in, let me let you know how you can get in touch with me. You can go to the link in the profile, or you can go to the link in the description of the video, and it will lead you to a page where you'll see a button to schedule your own consultation, or you can get in touch with the office by going to the link for the website. You'll see the phone number, you'll see online chat, you'll see the contact form. So those ways will all lead to the scheduling coordinators who will be more than happy to answer your questions about our service and help you to schedule that consultation. Thanks so much. It's one of my favorite dresses, so thank you. It's brightens up my day. Okay, so remember the CO8 interview I had in 5 minutes. I was approved, so congratulations. I'm glad to hear that. Congrats. So this and usually now after you're approved, so this is usually asylum and the COA, that's a work permit. After approval of asylum, it means after, if you've been physically present here in the year, then you can apply for permanent residence. So it means that it opens the door for other opportunities and a path to permanent residence and citizenship here. So congratulations. How long does a biometrics take from the USA? So it's usually like a 15-minute appointment. And there's no, I don't usually assign a length of time to the biometrics, just because once they take your biometrics, they add it to your file, they do the background check, and then they issue the work permit. But that can differ just based on the results of your background check. If you're trying to figure out when you'll get your work permit after the biometrics, I usually like to count from the date of filing, which depends on the type of application, but you could be looking at 3 months to up to a year. Okay. What if I'm currently married to a US citizen? Can I travel to the United States and do an adjustment of status? So you can't come to the US to do an adjustment of status. If you do that, they're going to turn you around at the airport. What usually happens is you're here already, you may be here on a visitor's visa, or if you are even paroled into the United States, then at that point they will grant you that you will be able to do adjustment of status. But it's usually a change of circumstances. When you're here, you decide to stay and then apply for adjustment of status. Um, uh, So I received my prima facie after 5 months of filing VAWA with adjustment of status. I did my biometrics last month for I-131. How long do these take to get my EAD? So you could be looking at 6 months to 12 months after the filing. So not necessarily after the prima facie, but after the filing. Um, So, so it seems this question has to do with the termination of F1 status, so the student status, and it's been 5 months. However, I know after 4 months later from my school, um, and I was ill. So is it possible to get my status back? So I'd have to evaluate what the circumstances are. There is a type of process that allows you to apply for reinstatement of your status. However, I'd have to evaluate the facts here to determine whether you'd qualify. Right. So go ahead, schedule a consultation, and we can talk about possible reinstatement. But I'll have to learn more about the facts here to determine what has happened. Um, all right. I'm just scrolling through to get the questions. What happened if you went on your N400 interview and they asked for evidence for child support and the child for that for a child living in another country and the mother of that child doesn't want to send it? So if you are sending child support, say via Western Union, those could be if you could get your money transfer receipts, that could possibly be evidence of your support of the child. But if the mother of the child doesn't want to send the evidence, then it's going to be a challenge. But there are other ways to show that you have been making payments or sending payments to the mother of the child. And one of those could be showing that you are sending money transfers down to the country. If your vow is approved, why would your waiver fee be denied for other stuff? Don't understand what they're saying if I give them the 1200. Yep. So if your vow is approved, now you're filing for adjustment of status. The adjustment of status does require a fee. And so you can apply for a waiver. It's really up to them, though. If you hadn't given them the evidence to waive it, they may deny it on that basis. But it's not a requirement that they waive the fee. You have to apply for it, and it's really based on their discretion, based on your income, your financial hardship, or if you're getting a means tested benefit. What steps does one take to get a work permit while on a tourist visa? So it doesn't work that way. This is, I've done so many lives about this, but if you're here on a tourist visa, you're not supposed to work. The work permit goes along with benefits. So if you qualify for a benefit or a form of relief here in the United States, so for example, say you want to apply for asylum, or you apply for the T visa, or you apply for FAWA, then it's in that case that you are going to get a work permit along with a benefit. But you can't just come, print out the form for the work permit and send it in to say you want a work permit. Actually, that's contrary to your tourist visa. And if they get wind of something like that, they can take away the visa. So you want to be careful about that. All right. You are welcome. Thanks so much for that comment on YouTube. I appreciate it. All right, so that's going to be it for me today. I'll be back tomorrow. So this week, I'm going to be talking about ways to get your paper straight, how to get your paper straight now, because we're focusing this week on the tools we have now to fix your situation while we hope for immigration reform to come very soon. And I am praying that something miraculous happens. We want to evaluate what's available right now, especially if especially in your case where there is some urgency to finding a solution now. And so this week, that's what I'm going to be talking about. All right. Have a good one. I will talk to you tomorrow at the same time, so lunchtime. Bye bye.